Bismillahirrahmanirrahim. Assalamu alaikum. My name is Hafsa Yasin and today we are here with another topic of public international law. So last time we have studied till Article 27 of United Nations Charter. Now we will continue it for Article 28. The Security Council shall be organized as to be able to function continuously. Each member of the Security Council shall for this purpose be represented at all times at the seat of the organization. Like there will be a representative of each country in the Security Council, and each of that member is responsible to be at the seat of the organization whenever they will ask for his presence. The Security Council shall hold periodic meeting at which each of its members may, if it so desires, be represented by a member of the country or by some other specifically designated representative. Like for example, if there is a periodic meeting, then its member or any of the member who wanted to represent its government can be there in the United Nations to represent their country. Then the Security Council may hold meeting at such places other than the seat of the organization as its judgment will be facilitate its work. It is not important or necessary that the meeting of the Security Council will only held in the organization or within the premises of the United Nations. Instead, it can be held at the seat. Instead, it can be held at any place which can facilitate the members or ultimately the if the judgment required to change its place to yes, it is possible. The Security Council may establish such subsidiary organs as it deems necessary for the performance of its functions. So if to perform a function it is important to establish a new organ for the National Security Council, then yes, the Security Council can establish that new. So if any member of the United Nations is not a member of the Security Council, then still the member can participate without the right of the vote, and they can present questions in front of the Security Council related to the matter that is considered with them. Like if they are the members of the United Nations but not the member of Security Council, still they have right to participate in the matter of the Security Council, or they can put questions to the Security Councils if the matter is linked with them, or if the matter basically direct affect that particular member state. Then Article 32, if any member of the United Nations which is not member of Security Council, or any state which is not member of the United Nations, if it is a party to dispute under consideration by the State Security Council, shall be invited to participate without vote in the discussion relating to the dispute. Like if there is a state and it is not a member state of the United Nations, or neither it is a member state of the Security Council, but matter that is to be discussed in the Security Council or in United Nations basically concerned with that non-member country. So Security Council will basically invite that country to participate in the discussion that is going to be happened in the United Nations, and they can, yes, they can actually stand for their stance in the United Nations. Then there's specific settlement of the disputes, Article 33, 34 and 35, and further we will also study about them. So the parties, Article 33, the parties to any dispute, the continuance of which is likely to endanger the maintenance of international peace and security, shall first of all seek a solution for negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, restored to regional agencies or arrangements or other peaceful means of their own choice. As if we can take an example of Pakistan here, we have a dispute with India about Kashmir, and if in any case this particular dispute affect the international peace or security, then yes, as we both are the member states of the United Nations. So what United Nations can do? United Nations can call both Pakistan as well as India, and they can ask us to negotiate our issues and to resolve those issues with the settlement or with our best interest. And if the matter is not resolved until yet, then the Security Council, when it is when it deems necessary, then basically call upon the parties to settle the dispute by such means. Like now, the United Nations will decide that how both the state can resolve this issue. As if we talk about the issue of Kashmir between Pakistan and India, so what Pakistan basically uh, asked that the decision in 1948 was taken by United Nations was like that now the United Nations will conduct a referendum in the Kashmir, and where the people of Kashmir will decide if they wanted to go with Pakistan or if they wanted to go with India. So now Pakistan wanted United Nations to take a stance, but because of some we can say some particular reasons, uh, the Security Council or United Nations is not taking any kind of stance for this matter. Then Article 34, the Security Council may investigate any dispute or any situation which might lead to international friction or give rise to a dispute, in order to determine whether the continuance of the dispute or the situation is likely to endanger the maintenance of international peace and security. For example, if there is a dispute or there is a matter between two states, as we can say there was this matter between Iran and Iraq, or there was this matter between Iran and America. So this was kind of a matter that can ultimately lead and it can give rise to the disputes, and this can further affect the uh, maintenance to international peace and security. As we have currently seen, there was an issue in Azerbaijan as well. So whenever there will be kind of matter, whenever there will be any dispute, the Security Council will investigate the matter, and then it can call both the parties and can ask them to resolve their dispute. And because uh, Security Council or United Nations don't want to basically we can say affect the international peace or the situation of security. Then Article 35, any member of the United Nations may bring any dispute or any situation of the nature referred to in Article 34 to the attention of the Security Council or of the General Assembly. Like if there is any matter that can affect the international peace and security, then that matter can be brought by any member of the United Nations, and United Nations will be liable to resolve that dispute according to the law. Then a state which is not member of the United Nations may bring to the attention of the Security Council or of the General Assembly any dispute which is a party of its accept in advance for a purpose the dispute the obligations of pacific settlement provide in the present chapter. Like if even if the state is not a member state of the United Nations, but and it bring attention of the United Nations or Security Council to a matter of dispute, and the matter can further affect the international peace and security, then yes, United Nations is liable to resolve that particular matter according to the rules. Then the proceedings of the General Assembly in respect of the matter brought to its attention under this article will be subjected to the provision of Article 11 and 12. Article 36. The jurisdiction of the court comprises all cases which the parties refer to it and all the matters specifically provided for in the Charter of the United Nations or in treaties or convention in force. Like any of the matter that is related to the international peace and security can be brought by the different parties in the United Nations, and United Nations is bound to resolve those all matters according to the convention or the treaties which are signed by the United Nations and which came into force by the United Nations to maintain the peace and security of the world, or to maintain peace or security internationally. Then the state parties to the present statute may at any time declare that they recognize as compulsory ipso facto and without special agreement in relation to any other state accepting the same obligation the jurisdiction of the court in all legal dispute concern. The member state can accept or can make any kind of agreement or can sign any kind of treaties without the concern of the or without the permission of the United Nations or Security Council if the matter is related to some kind of jurisdiction, or that some kind of legal dispute, if it is the interpretation of a treaty, any question of international law, the existence of any fact which if established would constitute a breach of an international obligation, the nature or extent of the reparation to be made for the breach of an international obligation. Then third, the declaration referred to above may be made unconditionally or on condition of reciprocity or on the part of the several certain states or for a certain time. Article 37. Whenever a treaty or convention in force provide for reference of a matter to a tribunal to have been instituted by the League of Nations or to the Permanent Court of International Justice, the matter shall as between the parties to present statute uh, be referred to the International Court of Justice. For example, if there is any kind of issue or there is any kind of conflict between the two states and United Nations decided to resolve that particular matter with reference to some treaty or with reference to some convention, then it is the responsibility of the United Nations or we can say the Permanent Court of International Justice to bring that matter, and they must mention that they are resolving that particular issue according to that particular treaty or that particular convention, and the matter will be referred to International Court of Justice. Or like if in future there is some related matter, then yes, they can give a reference of that previous matter, so the matter could be resolved easily. Then Article 38. The court, whose function is to decide in accordance with the international law such disputes are submitted to it, shall apply. There are some functions which will be resolved according to international law, and it will imply some special conditions. For example, international conventions, whether general or particular, establishing rules expressly recognized by contesting states. Like if there is an international convention and and this international convention is for some specific countries, then it is important that that particular convention must be recognized by all of the contesting countries or all the countries who are basically the core member or core members, or they are the basically one who are basically arranging that particular convention. Of course, the convention will be organized at some particular place, and all the member state will participate in that convention. But yes, they must recognize that yes, it was a good convention, or this convention can be taken as international law. Then international custom as evidence of general practice accepted as law. like uh, if there is a law, there is an international custom, or there is a rule, then that rule must be accepted by all of the states as an evidence or as a general practice. So they don't uh, they don't need to give any kind of argument about that law, because it is international law. Now it is important for you or compulsory for you to follow the law. Then the general principle of law organized by civil nations, uh, the subject to the provision of Article 59, judicial decisions and the teachings of the most highly qualified publicists of various nations as subsidiary means for the determination of rules and law. Uh, to provide the Article 59, the judicial decisions will be taken by the United Nations. That must be from the most highly qualified people, from who will belong to the different states, and they will determine the rule of law uh, that can be ruled in the court of international justice. Then this provision shall not prejudice the power of the court to decide case ex equo ad beno if the parties agree thereto. We will discuss about these terms in next lecture, inshallah. Thank you so much. If you have any queries, you can definitely ask.